Hello, my name is Adam Long, and this webinar is a series of follow-up questions from the spring 2014 employment management seminars that we presented across the state this spring. The purpose of this webinar is to address questions that were raised during the seminars, either that I could not answer on the spot or questions that perhaps came up in a number of the seminars and wanted to discuss them in a little more detail as part of the webinar. And finally, also to address questions that were written down and submitted but not actually asked at the seminar so that they could be answered as part of this follow-up webinar. The first question, and this question I believe came up in all three of the seminars, has to do with unpaid interns. Many districts use unpaid interns, whether they be college students seeking credit or receiving college credit for the internships, or even individuals interning over the summer that aren't receiving any credit for internships. And specifically, according to the U.S. Department of Labor, unpaid internships in the public sector where the intern volunteers without expectation of compensation are generally permissible. This is in rather sharp contrast to the use of unpaid interns in the private sector and the for-profit sector, where the use of unpaid internships is greatly limited and almost impossible in most circumstances. For conservation districts that operate in the public sector, the U.S. Department of Labor has indicated that unpaid internships are appropriate and lawful if the intern volunteers without expectation of compensation. However, in that same guidance, the U.S. Department of Labor has indicated that it's currently reviewing the need for additional guidance on internships in the public sector. So we certainly can say that right now, the U.S. Department of Labor would find that unpaid internships at public sector entities like the conservation districts are permissible. However, stay tuned for future guidance that likely will be issued by the U.S. Department of Labor on this issue. Also, it's important to note that the U.S. Department of Labor has jurisdiction for our purposes only over the overtime and minimum wage compensation laws. If a conservation district uses unpaid interns, it's still advisable for that district to confirm with its workers' comp carrier and liability insurance carrier whether and how these interns will be covered, because just because the U.S. Department of Labor says it's okay does not mean that the unpaid internships is not an issue under potentially the workers' comp laws, which are specific to the state here in Pennsylvania. So it's probably worth exploring, because as we would likely want these interns to be covered under the workers' compensation laws in the unlikely event of an injury or accident or something like that. Finally, if your district pays interns, and there's certainly nothing wrong with doing that, it eliminates any risk under any of the laws. If the interns are paid, we would advise that they be treated as temporary employees and not independent contractors. We talked at each of the sessions regarding the risks associated with treating individuals who regularly perform services for the conservation districts as consultants or independent contractors in lieu of employment. And if you were to pay interns, which again, pay them a minimum wage or something along those lines, then they would clearly be covered under the workers' compensation laws. Do so in a way that you treat them as employees to avoid any risk in creating an issue as you attempt to solve another. Another participant asked a question regarding wage discrimination and the risk associated with a wage discrimination claim if the district has interns the interns are either unpaid or paid less than employees who are performing comparable services. It's important to note that wage discrimination is a legal issue only if the different treatment is based on a protected trait, such as gender or race or religion. There's nothing in the law that says you must pay all employees in the same manner at the same rate for the same work. You can make distinctions based upon many factors as long as those factors are not a protected trait. So in a situation like this, if a district employs an intern as a, say, temporary employee over the summer and pays a minimum wage rate for that intern, and the intern may be performing duties very similar to that of a full-time employee of the district, I do not believe that that would create a risk of a wage discrimination claim, because there the reason for the different treatment seems to be quite clear, and that is a temporary employment slash intern relationship as opposed to a full-time employment relationship. So wage discrimination, while that is certainly a risk that we see more and more of that in the news every day, especially in the area of gender, that's not something, if the concern is paying an intern versus paying an employee, that's not a concern that I would say is a significant one in this specific area. We talked at each of the sessions regarding the travel time compensation rules for non-exempt employees. And we received a follow-up question asking for greater detail regarding how to handle overnight travel for non-exempt employees. And these would be circumstances where a district would send a non-exempt employee to a multi-day conference that requires overnight travel, whether it be flying somewhere or driving and spending the night as part of the multi-day conference or training or seminar. What travel time associated with such a trip would be compensable? Well, in a nutshell, an employee on an overnight trip, a non-exempt employee, must be compensated for all travel time that cuts across the employee's workday. And this is really strictly based upon the hours the employee normally works. If the employee typically works from 9 a.m. to 5 p.m., the employee must be compensated for any travel time that falls within that time period as part of this overnight trip, even if that travel occurs on a weekend or another day that the employee typically does not work. So if the employee works 9 to 5 Monday to Friday and then travels to a faraway destination as part of his or her job duties, and that travel perhaps goes from 10 a.m. to noon on Saturday, that travel time would count as compensable hours worked because it cuts across the employee's normal work hours, even though it's not falling on a day that the employee typically works. Now, if an employee travels outside of his or her normal working hours during a multi-day trip, the employer need not compensate the employee for that time spent traveling if, and only if, the employee is riding as a passenger in a car, bus, airplane, train, or similar mode of transportation during that time. So if the trip requires a flight, and the flight departs at 10 p.m. and arrives at midnight, and the employee's normal working hours are 9 to 5, that flight would not be compensable hours worked because the time spent in transit fall outside the employee's normal working hours. Now that said, if the employee is actually driving during the travel outside the normal working hours, the employee must be compensated, and that driving time constitutes compensable hours worked. So to sum up these rules, which are somewhat complicated, if you have an employee who's driving him or herself as part of an overnight trip, all time spent driving is compensable hours worked. And really all travel time on that trip is compensable hours worked unless they are riding as a passenger in a mode of transportation and the travel time falls outside their normal working hours. As I've said during the seminars, I'm just the messenger here. I recognize these rules are complicated and not always sensible either, but these are the rules that exist under the law and what we need to follow if we send non-exempt employees on overnight trips as part of their job duties. We received the question regarding an opt-out cash payment for declining health insurance coverage. And specifically, many employers offer employees, if they decline the employer's health insurance coverage, they offer them a cash payment as an incentive to opt out of the coverage. And the question that was raised involved how should that payment be treated from a taxable basis? And in a nutshell, payments like that, opt-out cash payments, are taxable if they are made outside of what's called a Section 125 cafeteria benefits plan. And in other words, if you're simply paying the employees out of your accounts payable or through the payroll system, a say $500 lump sum payment for opting out of the health insurance for a calendar year, that would be a cash payment outside of a Section 125 plan, and we should withhold taxes from such a payment. If you wish not to have taxes withheld from a payment, it must be made in the context of a Section 125 cafeteria plan, which is beyond the scope of something that we can talk about here. It's something, if you're interested in that, I would suggest that you talk to either your broker or your benefits provider regarding a Section 125 plan. Another issue to keep in mind, if you are making a cash payment outside of a Section 125 plan, meaning one just straight through your payroll, as we discussed, that payment may create overtime and regular rate issues for non-exempt employees. And this gets back to the discussions that we had regarding the payment of bonuses and how bonuses often need to be factored back into the regular rate for non-exempt employees if they worked overtime during the period that the bonus was intended to cover. So if you're making a payment, let's say the payment is on a yearly basis, that it's a one-time cash payment each year for opting out of the health insurance coverage, that payment needs to be apportioned over that year and factored into the regular rate for overtime compensation purposes. We talked about that, how that needs to be handled for bonuses during the seminar. It is somewhat complicated, but it is something at least worth flagging here, that these opt-out payments may have that sort of implication. Now, this is all said in the context that this whole area of the law is still relatively uncertain. Courts haven't really weighed in to a large degree on these positions. These represent the positions of the U.S. Department of Labor. Courts may disagree at some point, but for the time being, if we wish to operate in a relatively low-risk environment, we need to, if we're making these payments, we need to make sure we withhold taxes and consider the regular rate issues unless these payments are made as part of a Section 125 plan. We received a question regarding the psychological testing of a current employee, and specifically the employer in this case becomes aware that the employee suffers from mental illness, specifically a bipolar condition, and perhaps learns that the employee is not being medicated or is not adhering to his or her medication schedule. The question is, can an employer require a psychological test of an employee in a circumstance like that? And the answer to that question is an employer may require such a test if it can establish what's called the direct threat analysis. And that is, an employer can require a medical examination of an employee if it has a reasonable belief based on objective evidence that the employee poses a significant risk of substantial harm to either the employee or others. And this is not limited to mental health situations. This can be an employee where the employer becomes aware, perhaps has a back condition, and the job is such that it's a physically demanding job. If we have a reasonable belief based on objective evidence that the employee poses a significant risk of substantial harm to him or herself or others, we are permitted under the Americans with Disabilities Act to require that employee to submit to a medical examination to certify whether that employee can safely do the job. The law recognizes that we're not medical experts and an employee is not a medical expert. So even if the employee says, I'm fine, but we can establish that we have a reasonable belief based on objective evidence that we have concerns otherwise, we can require a medical examination or a medical inquiry in these circumstances. And in addition, the EEOC has recognized that if the employer can establish a potential direct threat situation, the employer actually can pick the healthcare provider who will do the medical examination. And this helps avoids a situation where you have a concern that the employee has mental health issues and the employee goes to his or her family doctor and comes back with a note, says, all clear, the employee's fine. To avoid a situation like that, we can say that the person needs to be reviewed or examined by a psychiatrist or a psychologist or something like that. So we can even pick the healthcare provider. However, when we require an examination like this, we as the employer must pay for all costs of the examination. The examination may be covered under the employee's health insurance, in which case the insurer should cover the costs that would otherwise be provided. But if there are other out-of-pocket costs that are incurred as a result of this examination, the employer needs to pay for those costs. So this is not a cost or risk-free option for employers to exercise. But that said, if you have significant concerns regarding an employee, regarding mental health issues or something like that, concerns that basically relate to safety, that is not a situation that you're forced to ignore under the law. Instead, if you can establish the direct threat analysis, if you can go through that analysis and feel that you can meet that test, you can require psychological or other medical testing of current employees in those circumstances. We also received a question regarding an employee with uncontrolled diabetes due to work-related stress. And specifically, the question asked if an employee who at one point had controlled diabetes or diabetes that was under control suddenly had the situation become uncontrolled due to work-related stress, what can an employer do? What is an employer's responsibilities in such circumstances? Well, diabetes is a disability under the Americans with Disabilities Act and the Pennsylvania Human Relations Act in almost all circumstances, I would say. And because of that, we have the duty to provide reasonable accommodations that are necessary to allow the individual to perform the essential functions of the job. So if you have this situation where suddenly you have an employee with uncontrolled diabetes, what you would need to do at that point is engage in what's called the interactive process to determine what accommodations may be needed. Now, if you simply know that the employee has uncontrolled diabetes but is still performing the job and has asked for no accommodation, you might have no responsibility to do anything. But if the employee has asked for accommodations or the uncontrolled diabetes is affecting the employee's ability to perform the job, that's when you would want to engage in the interactive process with the employee to determine what accommodations that the employee's healthcare provider believe may be necessary and determine whether they are reasonable and something that we can perform. One additional note worth mentioning is the reference in the question to the cause of the diabetes being work-related stress. There's at least the possibility of a workers' compensation issue here. And you notice I use the question mark there on the slide. I'm not saying that a situation like this is automatically a workers' comp claim, but under Pennsylvania law, workers' compensation covers injuries or illnesses incurred as part that are related to work. And if the work is causing the complications from the diabetes, there's at least a possibility in a situation like this that it may be a workers' compensation issue. I'm not saying necessarily that you should do anything in a circumstance like that, but just simply to flag this issue as a reminder that workers' comp covers far more than simply an employee who sprains his or her back lifting a box or somehow is otherwise injured in the line of duty. It really covers any injuries suffered that are related to work. And those can even be injuries that are not obvious, mental health injuries, things like that may potentially be workers' compensation issues. We received the question of whether the Pennsylvania Child Abuse History Clearance process provides information regarding perhaps child abuse claims that were filed in other states. And to the best that I can tell from my review, it appears that the Pennsylvania clearance is state-specific and limited only to information, reports that are made in the Commonwealth, and would not include other states. For example, if a report of child abuse is made against an individual in Texas and that individual moves to Pennsylvania, I do not believe that the Pennsylvania Child Abuse History Clearance would automatically indicate the Texas report. That said, each of the states has their own child abuse reporting procedure. And if you have concerns about an applicant or an employee regarding a child abuse report that may have been filed in another state, you can go through that state's processes to obtain their child abuse reporting information by working with that state directly. We also received a question regarding the Sunshine Act and the use of executive session specifically to discuss an employee disciplinary action. And the question particularly was, does the employer have an obligation to notify an employee if the employer's board wishes to go into executive session to discuss disciplinary action regarding that employee? And the answer to that question is the Sunshine Act itself does not expressly require the employer to notify the employee of the purpose of an executive session, such that there's no express requirement that we notify the employee, yeah, we're going to go into executive session to discuss potential disciplinary action against you. Now, that said, the Sunshine Act allows an employee to request in writing that a matter be discussed at an open meeting, an employment-related matter be discussed at an open meeting, in lieu of at an executive session. So this kind of an odd circumstance here where it appears that the law states that we're not required to notify the employee that we're going into executive session, but if the employee otherwise figures that out or recognizes that there will be an executive session in the future, that employee may request in writing that those discussions occur at an open meeting in lieu of an executive session. So in light of this sort of odd set of facts, what I would say in a situation like this is I think if it's otherwise appropriate, it may make sense to notify the employee that, look, the board's going to discuss potential disciplinary action regarding this incident and intends to do so at an executive session, giving the employee notice so that the employee then can request that it be discussed at an open meeting. While the law doesn't seem to expressly require that, that would seem to be a good practice in many circumstances in light of this other requirement that exists under the law. And keep in mind that any official decisions actually have to be taken at an open meeting under the Sunshine Act, and an employer may not use an executive session to adversely affect an employee's due process rights. As public employers, we need to be aware of that, the due process rights that exist under the Constitution, and we cannot use executive session to circumvent those rights. We received a question regarding employment law postings for districts that has county employees. In this situation, the district itself is not the actual official employer of its employees. Instead, the district's employees are officially employed by the county. And the question that was posed was, if county employees are in a separate county building, and does the district need to do its own employment law postings? And the answer there is, if the district is truly not the employer of the employees, the district is not subject to the posting requirements. While that's the simple answer, in reality the answer is probably more complicated than that, because we need to recognize that under many of these laws that have posting requirements, they recognize joint employment status, which is an employee may have multiple employers in a situation like that, depending upon the level of control exercised by the entities over the individual. And the joint employment analysis is very fact-specific and complicated. It's something to at least flag that if under the law, the district could be held to be a joint employer of these individuals, meaning it exercises some control over the employees. And in such a situation, both the county and the district could be considered joint employers of the district employees. And in such a situation, then the district potentially may be on the hook for employment law posting requirements if it's deemed to be a joint employer. So that's why I would say it's in the best interest of all districts, including those that have county employees as opposed to those that have its district-owned employees. It's in the best interest of all districts to confirm that the employment law postings for its employees are proper and up-to-date and regularly maintained. If the district has county employees, but the district's offices are in a separate building from the county's offices, and there are no employment law postings in the district's offices, and the employees infrequently, if ever, go to the county building, that may be an issue, and it might be something that a district may wish to address with its county to say, look, we think we should get the employment law postings up in our offices also, even though they're county employees, because that avoids this whole question of joint employment status and all of the complications that can arise from that. So it is, I think, a best practice to confirm that your postings are current and up to date. In the materials that we provided at the seminars, we have a list of those postings that you should make sure you make and have available to your employees. It's in the best interests of districts to confirm that even if the district's employees are county employees. Now, of course, if the county says we don't care, or that's we think they're fine, and you disagree, that it might not be obvious what the next step may be, but it's probably not a bad idea to at least raise the issue with the county if you believe that there may be employment that the postings may not be up to date and comprehensive. The question was also asked whether an employer must provide annual updates to its posters, its employment law posters. And the answer to that is not necessarily. There's no affirmative obligation to update the posters annually. However, there is an affirmative obligation to update those posters when the posters themselves are updated by the applicable government agency, such that if you're covered by the FMLA and the U.S. Department of Labor updates its FMLA poster and says effective X date, you're required to have the new poster posted, you should be aware of that and provide the updated poster and keep those posters up to date. So it's not necessarily an annual process, but it is one that you should follow. And at the seminars, we provided information regarding these posters can generally be found at the U.S. Department of Labor. They have a website dedicated to federal employment law postings, and the Pennsylvania Department of Labor and Industry also has a website dedicated to state law employment law postings. And so you may want to periodically review those sites just to make sure that your posters are up to date, and if changes were made, to get yourself a copy of the up-to-date poster. Those are all the questions that we had submitted as part of this process. Again, I appreciate the opportunity to spend the day with you at these seminars. I hope that you found the seminars to be useful, and I believe I'm going to have the opportunity to see many of you in June at an upcoming meeting in State College. So thank you all, and best of luck as you continue to manage your employees.